In 2019, a woman in Ohio walked into a nursing home. She was there to admit her mother. An administrator handed her a stack of papers. Standard admission forms, she was told. Necessary signatures, she was told. She signed. That signature cost her family $30,000. The form she signed was illegal. It had been illegal for 32 years. The signature was never required. It was illegal from the start. I'm going to show you the document they handed her. I am going to show you the exact law that makes it illegal. I am going to show you why nursing homes still get away with it. And I am going to show you exactly what to do when someone puts that form in front of you. Because the law has been on your side since 1987, and almost no one knows it. To understand the form, you have to understand 1987. Before that year, nursing homes across the country did something routine. When a family admitted a parent, the facility handed them a document. That document asked for a third-party guarantee of payment. It meant the adult child, the spouse, the sibling at the table agreed to be personally, financially, legally responsible for the resident's nursing home bills. All of them. Whatever Medicare or Medicaid did not cover. Whatever private insurance did not pay, the family member was on the hook. The contracts were clear. The consequences were brutal. Families lost homes. Savings were drained. Bankruptcies were filed. Congress held hearings. The testimony was ugly. Adult children described being told at the admissions desk, "Sign here or your mother cannot stay. Sign here or we cannot admit her. Sign here or she will be discharged." The coercion was structural. The financial devastation was predictable. So Congress acted. In 1987, as part of the Omnibus Budget Reconciliation Act, they passed the Nursing Home Reform Act. The law set federal quality standards for nursing homes participating in Medicare and Medicaid. That is virtually every nursing home in the country. Buried inside that sweeping legislation was a single provision, a prohibition. It said a nursing facility cannot require a third-party guarantee of payment as a condition of admission, expedited admission, or continued stay. It could not be done. The practice that had destroyed families for decades was made explicitly illegal. The law was passed. The regulation was codified. The protection was absolute. Families were safe. That was the theory. That was what Congress intended. That was what the words on the page said. But a law is only as strong as its enforcement. And the enforcement of this law has been almost non-existent since the day it was signed. The regulation sits at 42 CFR 483.12. Everyone remembers the date 1987. Nobody remembers the citation. But the words matter. The text states the facility must not require a third-party guarantee of payment to the facility as a condition of admission, expedited admission, or continued stay in the facility. Let me break down what that sentence actually means. A third-party guarantee of payment is any contractual promise by someone other than the resident to cover the resident's debts. That means you. It means the adult child. It means the spouse. It means the friend who drives them to the appointment. It means anyone whose name is not on the resident's own bank account. A condition of admission means the facility cannot make admission depend on that guarantee. They cannot say, "We will admit you, mother, only if you co-sign." A condition of continued stay means the facility cannot later demand a guarantee and threaten discharge if you refuse. The phrase is explicit. It covers admission. It covers the moment a resident is already inside. It covers expedited admission. The regulation is absolute. There is no loophole in the text. There is no exception for private pay residents. There is no exception for the first month of care. There is no exception for the adult child who appears financially stable. The rule is not complex. The facility must not require a third-party guarantee of payment. That is the end of the sentence. That is the entire legal obligation. The prohibition is clear. It has been clear for decades, and facilities still hand you the form. There is a second concept buried in the regulation that makes the trap more dangerous. A facility may ask a family member to act as a responsible party. A responsible party is an administrative role. You manage the resident's own income. You direct their Social Security check toward the nursing home bill. You handle their Medicaid application. You act as their agent using their resources. You do not use your own. The distinction is absolute. A responsible party is a fiduciary for the resident's money. A guarantor is a co-signer for the resident's debt. One is allowed. One is illegal to require. The problem is the admission packet often conflates the two. A single form can name you as responsible party and bury a personal guarantee in the same paragraph. Or the form labels you a responsible party in bold letters at the top, and then tucks the words jointly and severally liable into the fine print at the bottom. You think you are agreeing to manage your parents' finances. You're actually agreeing to become the bank. The signature line looks identical. The consequences are not. The admission form. That form is the central evidence. That single document threads through this entire investigation. It is the physical evidence of the violation. It is the thing they hand you in the moment you are most vulnerable. You are sitting in a fluorescent lit office. Your parent is in a hospital bed or waiting in a hallway. You have been told a room is available. You have been told the paperwork needs to be completed now. The administrator slides a stack in front of you. Here, sign here. Here, sign here. Here, initial here. Here. The stack might be 50 pages. It might be 80. The guarantee is on page 37. Or it is in an addendum. Or it is in a separate document titled Financial Responsibility Agreement. The language varies, the strategy does not. The facility knows you will not read every page. The facility knows you are exhausted. The facility knows you are afraid. They've done this thousands of times. You are doing it once. The power imbalance is the entire point. And buried somewhere in that stack is a clause that says you agree to be personally responsible for all charges incurred, or the resident, or any person executing this agreement shall be liable, or in consideration of admission the undersigned guarantees payment. The words are almost always the same. They almost always violate the law. They are almost always presented as mandatory. Most people sign. According to the National Consumer Law Center, the practice remains widespread in many facilities. According to Justice in Aging, nursing homes routinely include these forms in admission packets. The organizations have documented the issue for years. They publish guides. They issue reports. They file complaints. The data they have gathered suggests the violation is not rare. It is not an isolated bad actor. It is a systemic pattern. The exact percentage of facilities that insert these clauses is not perfectly quantified in a single definitive study, but the advocacy groups that track this issue describe it as common. The anecdotal evidence is overwhelming. Families report the same story in every state. The form is presented, the signature is demanded. The threat is implied, the debt arrives later. The demand letter arrives after that. The collection call comes next. The lawsuit is filed. The family discovers the signature was illegal only when a lawyer finally looks at the contract. That moment of discovery can take years. By then, thousands of dollars have already been paid. The money is gone. Here is a specific case. A daughter in Illinois admitted her father in 2016. The facility placed a document in front of her titled Admission and Financial Agreement and included a clause stating the responsible party agrees to be personally liable for all charges. She signed. Her father passed away 8 months later. The estate was insufficient to cover the outstanding balance. The nursing home sent her a bill for $19,000. She paid $3,000 over several months before an attorney advised her the clause was unenforceable. She stopped paying. The facility sent the account to collections. The collections agency called her weekly for a year. The stress sent her to a therapist. The legal bill to fight the collection was $4,000. She eventually prevailed. The signature was voided. The debt was extinguished. But she lost $7,000 in 2 years of her life. The facility faced no penalty. collections agency faced no penalty. The form is probably still in the admission packet today. No one told her the signature was illegal from the start. That is how the system works. The family bears the cost. The family bears the stress. The family navigates the legal system. The facility moves on to the next admission. Here's another case. A son in Texas admitted his mother in 2018. The facility demanded his signature on a guarantor agreement. He asked where it was. He was told it was a standard financial form. He hesitated. The admissions coordinator told him his mother could not be admitted without it. He signed. His mother was admitted. The monthly bill was $8,000. Medicaid eventually covered most of it after a penalty period. The gap bill was $12,000. The facility sued him personally. He defended the case pro se because he could not afford a lawyer. He argued the federal regulation. The judge dismissed the case. He won. The process took 11 months. He missed work for court appearances. His credit was damaged. The facility simply refiled the debt against the estate, which had no assets. The son's victory was real. It was also hollow. He was never made whole. The regulation protected him legally. Nothing protected him from the process. Here is the enforcement gap. The federal regulation does not include a private right of action. That means you cannot sue the nursing home directly under 42 CFR 483.12 for damages. The regulation is enforced through administrative channels. Complaints can be filed with the Centers for Medicare and Medicaid Services, the State Survey Agency, or the Long-Term Care Ombudsman Program. Those agencies can investigate. They can cite the facility for non-compliance. They can impose civil money penalties. They can threaten the facility's Medicare and Medicaid certification. Those are real consequences. Facilities fear them. But the enforcement process is slow. It is complaint-driven. It relies on families knowing their rights well enough to file. Most families do not know the regulation exists until long after the damage is done. The result is a protection that exists on paper and a practice that persists in reality. The gap between the law and the lived experience is measured in thousands of dollars. Let me describe the moment of refusal. It is the critical pivot. You are in the admissions office. The form is in front of you. You see the word guarantor, or you see the phrase personally liable, or you see the clause that says you agree to pay all charges incurred. You put the pen down. You say, I am not signing this. The coordinator will respond in one of several ways. The first response is often deflection. This is just standard paperwork. Everybody signs it. The second response is minimization. It is not a big deal. It is just for our records. The third response is escalation. If you do not sign, we cannot admit your mother. That third response is the one that breaks people. It is also the one that is explicitly, unambiguously illegal. Refusing to sign a third-party guarantee cannot legally be used as a basis to deny admission. The facility knows this. The facility may not care. The moment you say no, the power shifts. But you have to know what to say next. You have to know the regulation. You have to be able to cite it. You have to be willing to escalate if they push back. Here are the specific steps. Step 1. Identify the illegal clause. Look for the words personal guarantee, cosigner, jointly and severally liable, responsible for all charges, guarantees payment, or any language that makes you, not the resident, the payer. Step 2. Cross out the clause. Physically, with a pen. Write void next to it. Initial the change. Step 3. Write a note on the form. I am signing as responsible party only, not as personal guarantor, per 42 CFR 43.12. Step 4. Request a copy of the facility's written policy on third-party guarantees. Facilities often have such policies. Step 5. If the facility insists the signature is required, ask them to put that demand in writing on letterhead. The demand almost always disappears at that point. Step 6. If the facility threatens denial of admission, tell them you will be contacting the state survey agency and the long-term care ombudsman immediately. Give them the name of the contact if you have it. Step 7. Follow through. File the complaint. The state survey agency is required to investigate. The ombudsman is required to advocate. The facility will receive a citation if the complaint is substantiated. The process is not instant. It is not always comfortable, but it is the enforcement mechanism that exists. Use it. What if your loved one is already admitted? What if the form is already signed? What if the debt has already been demanded? The legal argument is straightforward. The signature was obtained under an illegal condition. The contract term is void as against public policy. The federal regulation explicitly prohibits requiring the guarantee. Any clause inserted in violation of that regulation is legally unenforceable. That does not mean the nursing home will not try to collect. They will. That does not mean the collections agency will not call. They will. But the legal shield exists. It has existed since 1987. Courts have dismissed these claims. Attorneys have used the regulation to defeat collection lawsuits. Legal aid organizations have form letters that cite the specific CFR provision. The National Consumer Law Center has resources. Justice in Aging has guides. The long-term care ombudsman can intervene. The law is on your side. The knowledge of the law is what was missing. Now you have it. Do not take that as legal advice. I am not your lawyer. Every situation is different. State laws vary. Some states have additional consumer protections that go beyond the federal regulation. Some states have more aggressive enforcement mechanisms. Some states have private rights of action under state law. You need to consult an attorney in your jurisdiction before making any legal decisions. But the baseline federal protection is clear. It has been clear for decades. The regulation is a shield. The knowledge of the regulation is what lets you raise it. There is a final pattern that needs to be named. The nursing home will sometimes frame the guarantee as voluntary. They will say the signature is not required, but it is helpful. They will say it just helps us process the application. They will say it is a backup in case Medicaid is delayed. The framing is designed to make you feel helpful, cooperative, reasonable. Do not be fooled. A guarantee that is not required is still a guarantee. It still exposes you to personal liability. It still puts your savings at risk. The fact that it was presented as optional does not change its legal effect. Signing voluntarily waives none of the consequences. The only safe move is to refuse. The regulation does not distinguish between voluntary and required guarantees in the context of admission. The prohibition is on the facility requiring the guarantee. But the facility can still ask, and many families, relieved that the pressure is lifted, will sign anyway. Do not sign anyway. The protection exists because Congress understood that families in crisis cannot make truly voluntary financial decisions. The moment is too charged. The stakes are too high. The imbalance is too great. That is precisely why the law exists. Honor that law. Use it. The admission form, that single document, has been the object of this investigation. It is the thing they handed to the woman in Ohio in 2019 that cost her $30,000. It is the thing they handed to the daughter in Illinois that cost her $7,000 in 2 years of her life. It is the thing they handed to the son in Texas who fought for 11 months and won but was never made whole. It is the thing that will be handed to someone you know tomorrow or next week or next year. The form looks official. It looks mandatory. It looks like every other document in the stack. The signature line is just a line. The words above it are just words. But those words have been illegal to require since 1987. The law was passed. The regulation was codified. The protection is absolute. The enforcement is what we make it. Every family that knows the law is a family that cannot be coerced. Every family that refuses the signature is a facility that loses the power to impose it. Every complaint that is filed is a record that the practice must stop. The law is not weak because it is unenforced. The law is waiting for people to use it. You are now one of those people. Share this. Tell your family. Tell your neighbors. Tell the person at work whose mother is getting older. Tell the friend whose father is in a facility now. The nursing home will not tell them. The admissions coordinator will not tell them. The form will not warn them. The knowledge has to come from you. 1987, 42 CFR 43.12. The signature was never required. It was illegal from the start. Now you know.